To get a bankruptcy started and to get this relief, and I think you called it a stay in bankruptcy,
Yes.
Is there a filing fee for this?
Yes, the filing fee for a Chapter 7 case is $306, and for a Chapter 13 case, the filing fee is $281. And that is money that actually has to be paid to the bankruptcy court when your case is filed.
Now, if you don't pay that money when you attempt to file the case, will the bankruptcy court issue a case number to you and allow you to take the benefit of the stay?
Once the case is filed, then you get the protection of the bankruptcy filing, and then you get what's known as the bankruptcy stay, Section 362 bankruptcy stay.
So what are the benefits for filing for bankruptcy?
Well, I think the primary benefit of somebody filing for bankruptcy is to get a fresh start. And what that means is, we can eliminate a lot of debts. Credit card debts, tax debts, repossession, foreclosure debts, things of that nature. We can stop wage garnishments. We can stop the IRS from seizing assets, from levying on your wages and your bank accounts. The biggest complaint that I have, people are in a financial difficult situation, is the harassing phone calls from the debt collectors and from the creditors. Once the bankruptcy case is filed, we can stop all of that harassment. Also, another benefit, Joel, is in dealing with primary residences and secondary residences. In a number of cases, under Chapter 13s, we can eliminate home equity loans or second mortgages on somebody's primary residence. As I've stated before, judgment liens can be removed. If you have a lien on your house, we can remove that. But the main focus is to get rid of debt and eliminate as much debt as possible to give that person a fresh start.
Now, quite a few people, I think, are under the misapprehension that by filing bankruptcy, they'll never be able to get credit again. Is that true?
Well, the bankruptcy filing itself does get reported on the credit report. But you've got to keep in mind that when you eliminate debt and you take person has a lot of debt and you get rid of that debt, going forward, that person is going to be a much better credit risk. If they go out to buy a house or they go to buy a new car, you get rid of the $20,000 or $30,000 in credit card debt and other personal loans and things of that nature.
It would seem to me that also knowing from the point of view of the creditor that the debtor can't file another bankruptcy for 8 years, would that not also help improve the credit score? Does that play a role?
I have found that typically a typical debtor, after being out of a Chapter 7 bankruptcy, they can reestablish their credit very rapidly if they do a couple of things. If they have a car loan, you make that car loan payment on time. If you have a mortgage, you make your mortgage payments on time. I always recommend that maybe go out and try and get a small credit card and use that credit card responsibly, but make the payments. And I found that within a 1-year period of filing, a lot of debtors have substantially increased their credit scores, and also at this point in time they've eliminated all that back debt. So
now I'm going to ask you a trivia question, and I looked this up. Did you know that Abraham Lincoln filed bankruptcy in the 1820s?
I did not know that.
Well, I guess the point I'm getting at is, in this economy, is bankruptcy still the stigma that it used to be?
Well, I think what you're saying is you're seeing well over 1 million bankruptcy cases filed every year in the federal courts. You have seen professional athletes file for bankruptcy protection. You've seen celebrities, actors, a lot of business people, for one reason or another, end up in bankruptcy. So I don't think it has the stigma that it may have had years ago. But Joel, at the same time, the bankruptcy laws have been around since 1800. And I believe in 1978 they codified the laws. But they've been around for a couple hundred years in this country.
And do you think that filing bankruptcy is, in fact, in somebody's best interest if they've got a large amount of unsecured debt?
Well, you've got to keep that in perspective because, when somebody's wages get garnished, and the creditor's going to take 25% of their take-home pay, They probably are not going to be able to make their car payments. They're probably not going to be able to buy food for their family. So, in a lot of these cases, it's not only necessary, but it's urgent to preserve the household.
Let's talk a little bit about going to court. Now, we know that's called the meeting of creditors. Can you explain to our viewers what a meeting of creditors is?
The first bankruptcy hearing is the Section 341 meeting of creditors. By this time, you've already filed your case. The court has docketed your hearing. In the Maryland, in the Baltimore district, all of the meeting of creditors are held at the federal courthouse in downtown Baltimore. Obviously, the debtor has to show up for the hearing. They have to be there. They have to testify. They have to have proper identification, and we're there to represent them as their legal counsel at that
Do they
hearing.
need to have their social security number on a printed document? Is that important?
Part of the documentation process is they like to see driver's license and a social security card for identification.
What if a person doesn't have a card? What do they do?
Well, in a lot of cases, if they can't find the social security card, they can present a W-2 form that has their social security number on it. Or if they don't have a driver's license, they can present an MVA identification card or possibly a passport. So there's other forms of documentation that are accepted.
Now, what is this hearing like? Is it like a courtroom drama where you're being cross-examined and grilled and made to feel bad? How does this go? How does this play out?
Well, the hearing itself is conducted by a trustee who was appointed by the bankruptcy court to administer these types of cases. Although I will say it's an informal hearing, the debtor is testifying under oath and answering questions under oath. So it's very important that person testify truthfully and provide whatever documents that the trustee has asked for in this process.
I've noticed that there's a large sign that says bankruptcy fraud carries a 5-year penalty. So are there any tips that you could give our viewers if you're filing a bankruptcy? I guess obviously the number one tip would be punctiliously honest, just totally honest about every question that you answer.
Yes, one thing I can say is full disclosure of assets, answer all questions truthfully, both in the bankruptcy petition and at the actual hearings themselves.
Okay. Now, when you actually complete the meeting of creditors, what happens next?
Well, the next step is the debtor needs to complete a debtor education class and obtain a certificate of completion, which we then have to file with the court. There is a 60-day period of time after the 341 meeting where any creditors can file objections. The trustee can file an objection for whatever legal reason they may have. Assuming that no objections are filed, the debtor would expect to receive a discharge letter after 60 days after that hearing, and that would conclude their case.